Welcome to Startup Spokane, and we're pleased to have you join us for our today's Lunch and Learn, which is the basics of employment law. And today we are joined by Angie Hayes. She is an attorney with Associated Industries, and thank you all for joining us today, and welcome to Angie.
Excellent. Well, thank you. Make sure that I'm standing in the right spot for purposes of the live stream. I can see my audience members here live, which is fantastic. Oh, and you, Chris, thank you very much. But thank you for having me. I'm happy to be here. I'm always, my favorite part of my job is getting out into the community and meeting other folks and working with people directly. I do a lot of my work by email, a lot of my work by phone. I was just on a webinar before I got here, so I don't get a chance to get out actually and meet people a lot or talk with people face to face. So I'm always happy when I get to be out here and live. My anticipation was the audience would be folks that were either looking to start businesses or starting companies or companies that are in a very maybe small, hence startup phase, but fun to have you two folks here from eTails that I know are working now at a very large company. So some of this stuff might not necessarily apply to you or probably is information that you may already know, but hopefully we have some folks in the live stream here that may not have had access or exposure to this information before. So again, my name is Angela Hayes. I'm an attorney here in Spokane. I practice exclusively in the area of employment law, working with a company called Associated Industries, where we provide services to businesses of all sizes, from two-person companies all the way up to Vista Utilities, for example, providing HR services, safety services, human resources services, and employment law services to organizations. So I spend a lot of time providing sort of backstop legal counsel to organizations on areas that focus in the area of employment law. So today we're going to talk about, I kind of picked out 5 topics that I thought would be important for new business owners to have in mind when they're getting started with their businesses. Anticipating the phase where you move from startup, where you're the only person working in the organization, or maybe you and another owner are working in the organization, ramping up to where you have at least one employee, that you need to have some of these employment laws in mind when you're taking care of those folks that are working for you. So I'll start off talking a little bit about independent contractors versus employees. Who are the people that are actually considered your employees in the eyes of the state and federal law? Independent contractors, one of the areas that's most commonly misclassified. Employers love to use folks or classify people as independent contractors because it gets them out of the scope of employment laws, where they'd have to do things like pay payroll taxes, worry about L&I and things of that nature. So employers oftentimes are doing a lot of contortions to try and get somebody to fall into an independent contractor category when they truly don't fit there. So I don't want employers to fall into that trap, classifying people as independent contractors when they really are your employees. So we'll talk about what that means to be an independent contractor versus an employee. Once you have those folks that you know they're your employees, what do you do when you're bringing them on? We'll talk a little bit about hiring and verifying your employees. We'll talk about classifying your employees. So once you have them in your employ, you know they're not independent contractors, you know that they're actually your employees. How do we know whether they're exempt employees or non-exempt employees? And we'll talk about what the difference is there and how you would discern whether somebody's going to be classified as an exempt or a non-exempt employee. Another area where it's very common for employers and people with a lot of HR experience to misclassify somebody as an exempt employee. Again, trying maybe to get around some of those overtime rules that would apply to your non-exempt employees. So we'll talk about fitting those folks into those classifications. We'll talk about paying your employees. What are some wage and hour basics? How much do you have to pay them? What are the overtime rules? Things of that nature. And then we'll talk about a couple of Washington state specific laws that employers might need to keep in mind, and particularly geared toward maybe the new employer who may not be aware of these things, but the Washington state paid sick leave law that just went into effect in 2018, and then Washington paid leave insurance that's going to apply to all employers in the state of Washington. Premium collection is going to begin in January of 2019, so important for employers to be aware of that. So with that, we'll dive into who are actually your employees. And again, the distinction is important because when you have at least one person working for you, you want to make sure that you've classified them appropriately. Folks who are your independent contractors aren't necessarily or technically considered to be your employees, and folks who are your employees and have different rules that apply to them. And again, I work with employers a lot who are tempted to classify folks that are providing services to them or working for them as independent contractors because it helps the employer get around things of having to take responsibility for that employer. And that employee, or for that individual that is providing work or services to the employer, to the organization. So very common to misclassify somebody as an independent contractor. Again, employers are oftentimes tempted to classify somebody providing work or services to them as a 1099 worker to avoid creating those employer-employee obligations. So having to comply with various state and federal laws with respect to those individuals, like providing them with paid sick leave, paid leave insurance, employment taxes, L&I, things of that nature. So employers will try and classify these people as independent contractors. The more control and dominion that an employer exerts over somebody providing services to you or to your organization moves that person from the classification of an independent contractor, somebody who is not legally your employee, into the area of being your employee. So really what the IRS, there's a whole number of different tests that somebody could look at to determine whether somebody providing services to you would be considered an independent contractor. But again, the main one that we often fall back, when to perform the services. Do they provide them with the equipment and the tools to provide those services? The more exercise and control as an employer that you're exerting over that person that's providing the services, the more likely that person really should be classified as an employee and not an independent contractor. I usually like to tell employers to think about it this way. The people that are your independent contractors are somebody that you bring in to do a one-off type of project for you. You're setting up your business, you need an IT person in there to set up your computers and set up your phones. That person's not necessarily going to be your employee. They're coming in for a specific period of time, probably under some kind of contract, a services contract that they're going to be providing the work to you, and then they're going to go away. They bring in their own equipment to set up the IT equipment. They bring in their own tools to get everything plugged into the walls. They have their own business cards. They have their own UBI numbers. They have their own, really have their own business. They're probably providing services to other employers as well. You're not their only gig. So those types of people, those would appropriately be classified as independent contractors. Again, they're not your employees. They're people that are providing kind of one-off services to you. When you have somebody, though, who's providing services in your organization that is really central to the organization. So say, again, that same IT person that's coming in and providing services. If your business is providing IT services to other organizations, like we're the IT, we hire a company called High Technique, and they come in and they fix my computer all the time, and they answer service calls and things of that nature. Hiring people in their business as the IT people, those are the people that are there to provide that service. Their entire business exists to provide IT services. You couldn't hire somebody as an independent IT contractor to come in and provide those services to that High Technique company because their whole business is providing IT services. So that person would be their employee. Some of the red flags, a lot of times we'll have employers that maybe they have somebody working in their employment and the individual had been there initially, properly classified, working there as their employee. They decide they want to leave employment, but maybe they just want to work part-time, or they don't want to be, maybe they just want to work a few days a week or something, have a different kind of working arrangement with the employer. When the employer decides then to hire that person back as an independent contractor, that can be a real red flag. They're doing the same work they were doing before, maybe on a different schedule, maybe not full-time, maybe they're doing a few different things that they hadn't done before. That's a real red flag when you get audited to determine whether somebody is truly an independent contractor. Have they worked for you before? Are they doing the same kind of work that they've done for you in the past? Again, does the employer still control the method, the means, and the manner of the work that's being done? And if so, that person really shouldn't be classified as an independent contractor. They really need to be classified as your employee. Volunteers, it can probably be pretty tempting as a startup organization. And again, I know you're not a startup organization anymore, but having folks that are there providing volunteer services to you. You have employees that maybe they have a regular day job with you and they want to stay after work a little bit and provide some volunteer services, doing some extra work for you. They realize that the company might be strapped for cash. They want to show that they're team players, so they're going to stick around and do some volunteer work. That absolutely is prohibited in the private sector. You cannot have volunteers you can't have individuals in your organization providing volunteer services to you if you are a for-profit organization. Really, the only people that can have volunteers are nonprofit organizations that have, usually of a religious or a charitable type nature, and having employees provide volunteer services. And even in that circumstance, in a nonprofit organization, you cannot volunteer for the same organization doing the same types of things that you do for that organization on a day in and day out basis. So if you are a for-profit organization, you can't have volunteers, basically. Might be tempting, as much as the employees want to be providing those types of volunteer services to you, again, particularly in the startup phase when they feel everybody wants to be, all hands on deck and pulling some weight, not going to be permitted, and it can have some serious ramifications for the employer if they have to go back, pay back taxes and things of that nature on behalf of those individuals. So, Once you've decided that you have these employees, you can't really bring them in as independent contractors. You know you can't have volunteers in your organization because you're a for-profit business. Hopefully, fingers crossed, you're for-profit. And what do you do now once you have those people in your employ? You're bringing them on, you're going to be hiring, and you're going to be verifying their employment. I just want to step back for a minute and talk about at-will employment. In the state of Washington, and in fact, all like 49 states with the exception of Montana is the only state that's not an at-will employment state. Employees are employed by default with employers in an at-will status. And what that means is that either party can terminate the employment relationship at any time for any reason, with or without any notice. So everybody's there at will. The employees can quit any time, the employer can terminate their employment at any time for any reason or no reason at all. Employers feel like that is a justification for, we've had this person in our employment for, they haven't quite hit their 90-day trial period, we're going to go ahead and let them go. And I always caution employers, even though somebody is an at-will employee, if you are going to be terminating their employment, it is best to have actually a reason to be terminating them, because what you don't want to have happen is you terminate somebody without providing them with any type of reason for the termination. And usually what happens is oftentimes those people aren't introspective enough to realize that maybe they aren't the best employee, maybe they really aren't getting the work, they don't understand what's going on, they're not a great employee. But if you don't provide them with a reason, and preferably a documented reason for terminating them, they can turn around and say, the employer terminated me for a discriminatory reason. They fired me because of my race, my creed, my color, my religion, my sexual orientation, any of those protected statuses. So even though somebody is an at-will employee, the employer still can't terminate you for a reason that would be considered discriminatory or against public policy. So keep that in mind. Even though your employees are at will, and you can fire them for any reason or no reason, you want to make sure that you don't give the appearance that you're terminating their employment for some kind of discriminatory reason. So again, always best to have some kind of documented reason for maybe they're having time and attendance problems, maybe they're having performance issues, they're just not getting the work down. There are some exceptions to at-will employment. Of course, if you have somebody in your employment that is actually with you under a written employment contract. Usually higher level executives will come into an organization and they'll have written employment contracts. In those contracts, it'll designate the reasons that somebody could be terminated. They're usually some kind of for-cause reason. They aren't considered at-will employees. You can't fire them at will or no will or for any reason or no reason. You have to comply with the terms of the written contract. Likewise, if you have employees in your organization when you get bigger, maybe they become unionized and you have a collective bargaining agreement. Usually the terms of the collective bargaining agreement would dictate when you can terminate employment of those individuals. But there are also some other times when at-will employment might inadvertently be converted into something other than at-will employment, really kind of without your intention or without your knowledge. So when you get large enough and you have a handbook, and if in your handbook you have a policy that says, we will provide progressive discipline in all cases, and it lists out, we'll give you an oral warning and then a written warning and a suspension and then a termination. If you promise that kind of treatment to your employees without giving yourself some wiggle room in the policy, you have essentially converted their at-will employment to, we can only terminate you once we've completed the steps of our progressive discipline policy. So I always encourage employers, if you're going to draft a progressive discipline policy, draft it in a way that gives you some wiggle room to say, we may provide progressive discipline in appropriate cases depending on the facts, that kind of fuzzy lawyer language. Just, give yourself the flexibility to do progressive discipline when it's appropriate and to be able to terminate somebody outright when progressive discipline just isn't going to be effective. So you want to make sure that you haven't accidentally converted your employees to something other than at will by promising them progressive discipline when you don't really intend to do that. Also, sometimes employers will have policies in their handbooks that say you must provide 2 weeks notice before you terminate employment. I always encourage employers to, again, give yourself some fuzzy language there. Say, we would prefer if you'd provide us 2 weeks notice, if you're going to leave employment with us so that we can prepare and, to conduct an exit interview or something like that. But once you say you have to give us 2 weeks notice, that essentially terminates or converts them to something other than an at-will employee, because now you're putting terms on their ability to leave employment with you. So that's another way that you can inadvertently convert somebody from an at-will employee to something other than that when you don't necessarily intend to do that. So generally, all your employees that are going to be with you, whether they are exempt or non-exempt employees, anybody that doesn't have a written employment contract with you, they're all going to be considered at-will employees. When you have anybody that comes into your organization that's going to start working for you, it's very important that you comply with the different requirements, and one of those is getting the I-9 verification process completed. So federal law requires that everybody on the payroll in your employment completes the I-9 verification process. And so after an employee accepts an offer of employment, the employee has to complete Section 1 of the I-9 form no later than the first day of work for pay. So the first day that they're in your employment for pay, and that can include the onboarding or the orientation period. That's considered hours worked for which employees have to be paid. That is not volunteer time. Again, those people can't be in your employment doing things like onboarding, filling out forms, learning about your company culture and things like that without actually getting paid for it. So that's considered work time for them, and they're going to need to complete their I-9 verification form no later than their first day. So usually employers will do this during the onboarding process. Employees are going to have to provide acceptable documentation to the employer. You can get on there's a link there for all the different information about I-9s. Employees have the right to choose which documents from the categories of documents that they will provide to an employer. The employer can't dictate what documents they'll accept and what documents they won't accept. That's up to the employee. If the employer is going to take photocopies of that information, they can. They're not required to, but if you're going to do that, if you're going to photocopy the passport or the driver's license or whatever they're providing to you, you want to make sure that you're keeping it in a secure place, and you better be photocopying it for everybody that you're completing the I-9 form so that you don't get into a case of discrimination that we only made copies of certain documents and not others depending on who was providing it to it. So be consistent in your practice. You're not required to do it, but if you're going to, you need to do it for all the individuals in the organization. And the employer has to complete Section 2 of the form no later than the third business day that the employee starts work for pay. So you have a pretty tight window in there in which you need to get those forms completed. And you're going to retain the I-9 forms for either 3 years from the start date or 1 year from the termination date, whichever date is later. So the employer has an obligation to keep those records available. In case you're audited and somebody wants to come in and take a look at those, you're going to have to provide those. So those are the two things I'd highlight with respect to the hiring. Now, you've got these people in your employment, you know they're at-will employees, you've got their I-9 forms completed. Do we pay these people or do we treat these people as exempt or non-exempt employees? This is another one of those areas. When you have independent contractors versus employees, that's an area that's very commonly subject to misclassification. Another one that's very subject to misclassification is when you have employees who you are paying as exempt employees versus non-exempt employees. And I will tell you that most likely most of the people that you're going to have in your employment should be treated as non-exempt hourly employees. And in fact, you could treat everybody in your organization as hourly non-exempt employees, all the way from the owners of the company on down. It doesn't make any difference. There's no requirement that you treat somebody as an exempt employee, but you can't, it doesn't go the other way. You have to make sure if you're going to treat somebody as an exempt employee, which takes them out of the protections of the Minimum Wage Act and overtime rules and some of the record-keeping rules, that they fit properly within those exemptions. Because if you've misclassified somebody as an exempt employee, you may have to go back, end up paying them overtime for all the hours that they worked for. You can go back as far as 3 years if it was an intentional misclassification of the employee. So it can be pretty significant for an employer if you've misclassified somebody. So you want to make sure that the duties and things that the employee is doing really fit within one of those exempt categories if you're going to classify somebody as exempt. So some of the basics with respect to these exemptions: all employees have to be paid minimum wage and overtime unless they fall into one of the exemptions that I'm going to just talk about briefly. There's a presumption that all employees are non-exempt unless the employee fits within a very narrow category that's defined by state or federal law under the Washington Minimum Wage Act and the Fair Labor Standards Act. So those are the state and federal laws that apply to this area. I said down there at the bottom that the exemptions are very narrowly construed against the employer receiving the exemption. That's not necessarily true anymore. With the change in the National Labor Relations Act, or the board and the administrative agencies that interpret these rules, we're seeing this pendulum shift in the Trump era. These rules aren't necessarily narrowly construed against the employer anymore, and there was a Supreme Court case out just recently that kind of did away with this narrow exemption interpretation, narrow construction interpretation. So I don't think that really gets the employer out of the woods. I think you still need to make sure that these individuals really fall properly within the classifications if you're going to move somebody from a non-exempt to an exempt category. Again, using exemptions is optional, so you don't have to have anybody in your organization that's considered exempt. It's, I'll say, a privilege as opposed to a right. You can make them exempt if they properly fall within an exemption, but you're not required to do that. So what are these employees exempt from? When I say you're an exempt employee, what does that mean? What does it mean you're exempt from? You're exempt from certain categories. So certain categories of employees And the ones that you mainly hear about are the executive, the administrative, and the professional exemptions. There are some others. There are some computer exemptions. There's some outside sales exemptions. I'm not going to necessarily touch on those today, but the three big ones that are in the mostly at the forefront and are the most commonly used would be the executive level exemption, the administrative exemption, and the professional exemption. Those individuals who are properly classified in those exemptions are exempt from overtime, they're exempt from minimum wage requirements, they're exempt from record-keeping requirements, and some employment standards in the state of Washington. So for example, they don't get overtime pay if they work more than 40 hours in a week. They get paid the same amount of money week in, week out, whether they work 10 hours or 40 hours or 80 hours, it doesn't make any difference. They don't get paid additional time for travel time like you would as a non-exempt employee. They don't keep track of their time for payment purposes. You can't make deductions from their paychecks if they work fewer hours than you would like or fewer hours than you anticipated. They don't receive rest and meal breaks like they are mandated for non-exempt hourly employees. So they're exempt from some of those different rules. An employer can jeopardize an employee's exempt status. So if you have an employee that you've made an exempt employee and maybe they properly fall within an exemption, maybe they properly fall within the administrative or the executive level exemption, and you start doing a bunch of stuff with that employee, for example, making improper deductions from their paycheck. So you have somebody that you anticipate, you have an executive level employee, they're supervising 2 or more individuals within your organization, they're a supervisor. You expect that person to be in the office working 40 to 50 hours a week. You see that this person's taking off a lot of time maybe to play some golf, they're going out to the lake, they're not getting to the office as often as you'd like them to be, and they're only working 30 hours a week. Makes the employer mad, so they decide to deduct. They've been keeping track that the employee's only been there 30 hours that week, so you make a 10-hour deduction from their salary. That would jeopardize the employee's exemption, because what you're doing now is you're treating that person as a non-exempt employee. And if you were ever audited, that probably would convert that person and maybe everybody in that same job category that you've classified as exempt into a non-exempt category. So you want to make sure that you're not doing things to your exempt employees or requiring things of your exempt employees that would make them look like you really are treating them like non-exempt employees. So important that if you're going to classify somebody as exempt, you treat them truly as exempt. It doesn't necessarily mean that you can't require exempt employees to keep track of their hours. So for example, oftentimes in somebody who falls under a professional exemption, like an engineer, for example, those individuals may have a lot of different projects that they're working on, and the employer needs to bill their different clients for the hours that that professional engineer is working. It's not going to jeopardize that individual's exemption by making them keep track of their hours so that you can properly bill those hours to the clients. It's only when you start doing things like taking things away from that employee, like money, that might jeopardize their exemption. Likewise, if you make a decision, you have an exempt employee, and again, part of the exemption is that they get paid the same amount of money week in and week out without regard to the amount of work or the number of hours that they're working. If you decide maybe you want to give that person a bonus, or you want to pay them additional money for working more than what you would normally expect them to do, courts have said that that also doesn't jeopardize the exemption. Giving them something more than what you normally would isn't going to create a problem for those exempt employees. So how do you get to be exempt? How do you get to fall into this magic category where you're exempt from minimum wage and overtime requirements? And likewise, you probably have a more flexible schedule, maybe because the employer, you're not necessarily punching a time clock, you're not necessarily keeping track of your hours like that. Maybe you're working 30 hours one week, 50 hours the next week. You have a little more flexibility sometimes as an exempt employee. So to truly be an exempt employee, following in one of those categories that I talked about, you have to generally meet all 3 of these following tests. You have to meet the salary threshold test, and there was a whole bunch of discussion about this last year in 2017 when the feds tried to raise the salary threshold exemption from $455 a week to $913 a week, which would have left a whole bunch of people no longer meeting the salary threshold test and suddenly going from exempt to non-exempt because the employers just weren't willing to or able to pay them enough money. So anyway, those have kind of gone by the wayside. The feds are on a listening tour right now to find out what they should be raising the salary threshold exemption to, but right now it stays at $455 a week. So what that means is they're making $455 a week. That's the salary threshold. They can't be making any less than that. They usually are making more than that, but that's the minimum that they can be paid. They have to be paid on a salary basis, and what that means is they make the same amount of money week in, week out, without regard to the quantity or the quality of the work that they're producing. So whether they work 10 hours, 1 hour, 30 hours, 50 hours, 80 hours, doesn't make any difference. They're still paid at least $455 a week, whatever the salary is that they're paid. They're paid the same amount of money week in and week out. And they satisfy the duties test. And that's really the real tricky part is the employee engaged in the duties that are contemplated under one of those exemptions. So, for example, under the executive level exemption, that individual has to be somebody who is supervising at least two or more full-time or full-time equivalent individuals within an organization and has a number of other duties that they perform. So not only does that person have to be making at least $455 a week in, week out, they also have to be meeting the duties test. And if the employee doesn't meet the duties test, it doesn't make any difference how much money you're paying them. You could be paying them $100,000 a year. It doesn't make any difference. If they aren't meeting the duties test, they aren't going to fall properly within the exemption. Under federal law, there is an exemption for highly paid individuals. So if you make over $100,000 and some odd a year, the feds consider you to be exempt no matter what kind of duties you're performing, essentially. That does not apply in the state of Washington. So the state of Washington doesn't interpret that the same way. They don't have that particular exemption. So just make sure that you're not using that in the state of Washington. So even if you have some very highly paid receptionist, for example, who's making over $100,000 a year, she's been with you for a long time, you find her very valuable to the company, she's not going to meet probably any of the duties tests for the executive, administrative, or professional exemptions, doesn't meet the duties test. She certainly makes enough money, but she isn't going to meet the duties test, and no matter how much money you're paying her, she's not going to be considered exempt, and you could find yourself with a whole lot of overtime on your hands that you have to pay her if it's found that she's actually non-exempt and has been working anything more than 40 hours in a week. Down there, the link that I've provided, a really good comparison chart between the duties that have to be performed under federal law and under state law. They're usually pretty closely entwined. The main one that I pointed out is that highly paid individual. Washington State doesn't recognize that, but that'll give you a good idea of the duties that somebody would have to be performing under the executive, professional, or administrative exemptions to meet the duties test and be considered exempt. So now you've got these people, you're properly classifying them as either exempt or non-exempt. What do you have to do with respect to paying your employees? So with respect to your non-exempt hourly employees, which is probably going to be most of your workforce, again, unless they fall into one of those exemptions, employers have to pay non-exempt employees at least minimum wage for all hours worked, and we'll talk in a minute about what hours worked means. Washington minimum wage in 2018 is $11.50 an hour. Next year it goes up to $12 an hour, and in 2020 we hit $13.50 an hour, and then it's going to go up incrementally from there depending on certain factors. Idaho, if you have Idaho employees, they're still following the feds. $7.25 an hour is all they're getting paid. Employers could pay them more, but all they're required to pay their employees in Idaho is $7.25 an hour. Employers have to pay all non-exempt employees overtime, meaning they have to be paid time and a half, for every hour worked over 40 in a single work week. So you look at it on a 7 consecutive day basis, week by week basis, not on a 2-week basis. So somebody works 35 hours one week and 45 hours the next week, even though they've worked a total of 80 hours, they're going to be getting overtime for those extra 5 hours that they worked in that second week of the pay period. They worked 35 hours the first week, 45 the second week. They're going to have 5 hours of overtime coming to them for that second week that they worked. So important for employers to understand that it's a 7-day period of time. You have to pay the employees overtime even if you didn't authorize it. So a lot of times employers will have policies in their handbook that say, we don't pay overtime unless it's pre-authorized. The enforcement agency doesn't care whether you authorized it or not. If they work it, you have to pay it. And if you have an employee who is incurring overtime without authorization, I think the appropriate thing to do is take them back, take them aside and treat it as a performance issue. Is there a reason you aren't completing your work in the 40-hour work week? We can't be incurring, significant overtime. We don't have the budget for it. You can require that they not work overtime, but if they've worked it, you have to pay them for it. And then again, follow up and treat it as a performance issue for those individuals. Comp time in lieu of overtime. So sometimes employers will say, and actually if you go to the Washington State Department of Labor, the L&I website, they'll talk about comp time on there, which is a little bit misleading because under federal law, under the Fair Labor Standards Act, comp time is not permitted in the private sector. There is a bill before the Senate right now. It passed in the House and it's sitting before the Senate, it's floating out there somewhere. I don't know what's happened to it. I was trying to research this yesterday. I don't know where it is, but a comp time bill saying that employees can have the option to choose, instead of getting overtime pay, instead of getting time and a half for every hour of overtime that they work over 40 in a single work week, they can choose instead to get 1.5 hours of comp time. So basically bank an hour and a half of some kind of paid leave in lieu of getting that overtime pay. Not currently allowed in the private sector. It's a misconception by a lot of employers in the state of Washington that they can provide comp time to their employees or require employees to take comp time in lieu of overtime pay, and you can't do that currently. So we'll see what happens with this federal law that's, like sleeping before the Senate. I don't really know where it's at, but that comp time bill would propose that employees would have the option. Employers could make that option available to the employees. The employees could select that option if they wanted to get comp time in lieu of overtime at the rate of 1 1/2 hours of comp time for every hour of overtime that they work. They could accrue up to 160 hours of comp time a year, cash it out on a yearly basis, or the employer would have to pay it out upon termination. My understanding is that there would be no carryover provision, so the employee would have to either use up to 160 hours of comp time in the year, or they'd have to cash it out at the end of the year. My impression is also that the employer has the option of offering that option to the employees or not. The employer can't make the employees take comp time in lieu of overtime, but they could offer it to the employees. There may be some employers that aren't interested in doing that, because like suddenly if everybody's using comp time and like you have a big project that needs to be completed and everybody's off on their comp time that they've been banking, you don't have anybody to do the work. I'm not really sure where that's going to leave employers. Or likewise, they may not be interested in suddenly having to make all these balloon payments at the end of the year to these employees that have been racking up all this comp time. So I don't really know exactly where it's going. Go ahead. Yeah.
Did comp time used to be legal in some jurisdiction, or where did the concept come from if it's not even legal?
Well, in public sector, it's permitted. For employers that fall under the threshold of being subject to the Fair Labor Standards Act, I think that's why it's on the Washington State, Department's website. I mean, they talk about comp time on there, which has always kind of been a mystery to me, because most of the employers are subject to the Fair Labor Standards Act as well, and the Fair Labor Standards Act is pretty clear, saying that it's not permitted in the private sector. So I think it is a little bit misleading, and I don't know exactly where it would be applied other than in the public sector, on a nationwide basis, exactly for that reason. Because if you've got federal law that says it's not permitted in the private sector, I don't know. I mean, that's going to apply to most everybody, unless for some reason you fall under like the $500,000 threshold of business and the interstate commerce requirements of being subject to the Fair Labor Standards Act. So I guess if you're tiny enough that you don't fall under the Fair Labor Standards Act for some reason, and that law doesn't apply to you, then maybe you could utilize comp time in a very, very small business that isn't engaged in interstate commerce and isn't doing enough business to be subject to the Fair Labor Standards Act. And I don't know who that would be. I mean, I guess if you're, I don't know what kind of businesses those would be. You don't see a lot of businesses that aren't subject to the Fair Labor Standards Act, particularly with the interstate commerce issue, because you're doing any kind of doing any kind of internet business, taking credit cards, getting mail from outside, then you're going to be subject to the Fair Labor Standards Act. So might be one of those things that just hasn't kept up with the developments in the law. It's good, but excellent question. Employees have to be paid at least one time a month on a regularly scheduled payday. Most employers do it twice a month, but you have to pay them at least one time a month, and it has to be on a regularly scheduled payday. Back here when I said they have to be paid for all hours worked, there can be sometimes some misconception as to what hours worked means. Again, there can be no volunteer services provided to your for-profit organization. So you have maybe you are an organization that is, you have your business going on during the daytime, and then some evening you're going to sponsor an event and you need employees there to help set up for the event, or tear down the event or something like that. Employees have to be paid for that time. That's going to be considered hours worked. They are there at the subject and the behest of the employer. They're providing services to the employer. May not be the same type of services that you provide in your day business, but if they're there doing something on behalf of the employer, that's going to be considered hours worked for which the employees have to be paid. And it may put them into an overtime situation if you have events and things like that you're requiring your employees to attend or participate in. That might put them into an overtime situation. So time worked can also include things like orientation. There is no such thing as a free orientation. You bring your employees in for onboarding, they're going to be subject to, or that's going to be considered hours worked on behalf of the employer. Time spent before and after shift, usually the employer will have a requirement that says you can't clock in any more than 5 hours before the start of your shift, can't clock out any more than 5 minutes after your shift is ended, to avoid that issue of we have these people hanging out there and are they really doing work, or are they working off the clock, something along those lines. So you want to make sure that if you're keep tight timekeeping practices with respect to something like that, so you're not incurring additional hours worked that you didn't necessarily intend to. Hours worked doesn't include paid time off, sick time, things like that. When somebody's on vacation, that isn't considered hours worked. Just because maybe they have some paid vacation available, they take 40 hours at the vacation bank. That 40 hours isn't considered hours worked for purposes of payment. Generally, there's no maximum cap on the number of hours that an employee can work in a single day. Overtime is going to apply, though, for your non-exempt employees, but on a week-by-week basis. So you could have employees that are working 12 and 13 hours a day, but as long as they work less than 40 hours in that week, they aren't going to be entitled to overtime. There are some exceptions to that, like certain requirements for nurses and things of that nature where they may have shift differentials that you have to engage with. PTO, vacation, premium pay, shift differentials, those types of things, holiday pay, generally not required. There's no state law or federal law that requires you to pay somebody for a holiday, no state or federal law that requires you to pay somebody vacation benefits. The only thing now, state of Washington, we do have paid sick leave that's mandated by state law that you do have to provide those hours to the employees. And here's just a little breakdown of rest and meal breaks with respect to your non-exempt employees that you need to be providing to them. So regardless of the size of the employer, you have obligations under state law to provide certain rest and meal breaks to your non-exempt employees. For your exempt employees, they're not subject to these same, this is one of those things that they are exempt from. They are exempt from these kinds of labor standards that are required of your non-exempt employees. So employers are required to provide a paid 10-minute rest break for every 4 hours of work. Ideally, you're going to provide that at the midpoint, into the first 2 hours. It can't be provided any later than into the first 3 hours of work. Those breaks, they can't be waived or saved. I would recommend that you keep your employees on the premises during that time because they're still there on the clock for you. So, they go out in the parking lot to smoke and fall down and break their leg. That's an L&I claim for you. Keep them close. They can't get very far in 10 minutes or 15 minutes or whatever you're going to provide them for that paid break. Sometimes you'll have a situation where, providing employees with a 10-minute break when you're working on a manufacturing line is a little bit easier because you'll usually be rotating those people through their breaks, and the employer's usually very regimented about getting people to get those paid breaks in. Sometimes, however, though, maybe you're working in an office setting that's a little more casual, and you have employees that can get up kind of at will whenever they feel like it. They can go into the kitchen, take a break. Maybe they're going to check their email, make a private phone call, get something to eat, get some coffee. They're chatting around the water cooler, and by that time they've taken a 10-minute break and they get back to their desk. Those intermittent breaks are okay. So if you're not doing regimented breaks when you're in that more casual setting, that will still be acceptable as long as you're allowing your employees to do that. Meal periods has to be a minimum of 30 minutes. These can be unpaid. If the employee is interrupted by work, or if, for example, you require the employee, say, for example, the person who's answering the phone at the front desk, you require him or her to stay at the front desk during their lunch break in case a customer comes in and they need to greet them, they need to be available for that. That probably isn't going to be considered necessarily a meal break, or if they get interrupted and have to do work during that time, that's going to interrupt their meal break and you're going to have to be paying them for that time that they're working. Employees sometimes will want to waive their meal breaks. Say they want to leave 30 minutes early. Can you allow employees to wait? Can't allow them to waive their paid breaks, but you can allow them to waive their meal breaks if they want to do that. I usually recommend to employers, if you're going to have them do that, just do it on a case-by-case basis. I worked in a situation with the law firm where I worked. One of the employees wanted to waive her meal break so she could leave at 4:30 every day so she could catch a different bus. And then all the other staff members got wind of this. And then everybody wanted to leave. Nobody wanted to take a meal break. Everybody wanted to leave at 4:30. And then you have a bunch of lawyers sitting around and nobody knows what to do without staff people there. So that didn't work out very well. The employer has the right to control that. You have the right to control if you allow your employees to waive their meal times. You don't have to allow it. But if you are going to allow it, I would do it on a case-by-case basis. On special occasions, circumstances, somebody needs to leave early to catch a kid's soccer game or make a medical appointment or something like that. And I would typically tell the employer it's best to get it in writing if they're going to waive it. So some Washington-specific laws that employers in this state should probably be aware of. Of course, Washington State paid sick leave law applies to all employers regardless of their size, and applies to any individual that's covered by the Minimum Wage Act. And so specifically, that would be your non-exempt hourly employees. Exempt employees in your organizations don't have the same right to Washington State paid sick leave. A lot of employers are just providing it to those employees anyway because it's maybe easier to administer. But this really is going to apply to your non-exempt hourly employees. Likewise, doesn't apply to your independent contractors, but now that we just had that discussion about independent contractors, nobody's going to use them. So independent contractors aren't entitled to Washington State paid sick leave if you have somebody that you're employing or you have in your organization as an independent contractor on a very temporary basis. So Requires an employer to provide 1 hour of paid leave for every 40 hours worked. Again, hours worked is just as it was defined and we discussed earlier. There is no cap on the amount of hours that somebody can accrue in a single year or that they can use in a single year. But the employer has to allow employees to carry over up to 40 hours a year. So if you have somebody who's banked a whole bunch of paid sick leave and they get to the end of the year and they have 160 hours, the employer only has to allow them to roll over 40 hours into the next year, and they lose the remainder of that balance. You don't have to buy it back from them. You don't have to buy this from them when they leave. This is not something that has to be cashed out to the employee. Employees can use the paid leave for any authorized purpose, and that's authorized purpose under the statute is defined as the employee's mental or physical illness, injury, or health condition, their medical diagnosis, care, or treatment of a mental or physical illness, injury, or health condition, or preventative medical care, or to care for somebody else with any one of those conditions, one of employee's family members that has one of those conditions. There are a couple other circumstances in which an employee might be able to use that, which would include somebody's school or place of daycare is closed due to order of a public health official. They'd be able to utilize paid leave benefits for that. Doesn't necessarily apply to bereavement leave, doesn't apply to snow days or inclement weather. You can allow your employees to use it for that purpose if you want to, but that's not an authorized purpose under the statute. Employers can't retaliate against employees for using leave for a proper purpose. And it's very hard to gauge when employees are using something for a proper purpose because you can't ask for verification that they're using leave for an authorized purpose until they've been gone for more than 3 consecutive work days. So that can make it very challenging for employers when you have somebody who suddenly is taking paid sick leave on a Friday and a Monday, and then they come back on a Tuesday. Employers are finding that, I think, to be a very frustrating thing because you can't ask for verification or a doctor's note or something like that because they haven't been gone long enough under the statute to be requiring that type of verification. So if you have policies that say we'll require a doctor's note when you've been gone 3 days, you might need to adjust that policy because you can't do that anymore. You have to wait until they've been gone more than 3 days to be able to ask for that kind of verification. So sometimes employers will need to go back, and I've done a lot of work with employers over this past year in updating their policies to make sure they're in compliance with the new law. Likewise, you can't impose discipline for using leave for a proper purpose. So if you have a no-fault attendance policy and you have somebody who's been taking paid leave under the Washington State Paid Sick Leave Statute, you can't count those absences against them for purposes of a no-fault attendance policy. Those are basically protected absences that they would have with the organization. So you might need to go back and take a look at your policies with respect to that as well. And then Washington Paid Leave Insurance, this is coming soon. So this is a Washington State Paid Sick Leave. The names are almost a little bit too similar. So the paid sick leave is going to be to tend usually to those illnesses that are a little more minor. You've got the stomach flu, you've got a cold, you've got a medical appointment, your kid's sick, something like that. This paid leave insurance is something much bigger. It is for those events that would be considered a serious health condition. Washington was only the 5th state in the nation to implement a paid leave program. Benefits are going to be available for family care, so you're going to have 2 different buckets of leave under this paid leave insurance program. Also, back up for a minute, this paid leave insurance program is actually going to be administered by the Employment Security Department. It's not going to be part of the Department of Labor and Industry. It's not going to be administered by L&I like workers' comp or something like that. It's going to be administered by ESD. And ESD is going to be the one that is reviewing the claims or reviewing the applications for benefits. They're going to be the ones that are going to be cutting the checks and things of that nature. So administered by that department. Benefits are going to be available for 2 different buckets of needs. So there's going to be a family care bucket, which is going to be for an employee to care for the serious health condition of an employee's family member, very broadly defined. I mean, it includes basically everybody that's living under your roof that's related to you. It could be your in-laws, it could be your nieces, your siblings. And it's not nieces and nephews, but it's siblings, parents, spouses, registered domestic partners, children, again, in-laws. So if you're committed enough to your in-laws that you want to take time off from work to get paid leave benefits to care for them, you can do that. It can be used for baby bonding purposes. So once you've had a baby, that 12-month period of time following the birth of the child or following the placement of the child through foster care or adoption, you can utilize these paid leave benefits to take time off to bond with that individual. It could be used for certain military needs. Then there's also going to be a medical care bucket. So that's for the employee's own serious health condition with respect to, again, employee can take time off and get paid leave benefits if they're eligible for them for their own serious medical conditions. Premium collection is going to begin on January 1st of 2019. So employers are going to have to start now, probably pretty soon, gearing up for advising your employees that there is going to be money coming out of their paycheck to fund this program. Benefits are going to be payable for a year, so we're going to build up this insurance fund. So employees are going to be seeing this money coming out of their paychecks. Employees, you may have pushback from employees that say, I don't want to fund my family leave bucket because, one, I don't have any family that I want to take care of. I'm not going to have a baby. I'm not going to do any of those things. I don't want to fund that. Or I'm perfectly healthy. I don't need to fund a medical leave bucket. They don't have an option. You can't opt out of this as the employee. The insurance, again, this is going to be funded through premium collections out of in two different sources. It's going to be set at 0.4% of wages, gross wages, again, beginning January 1st of 2019. 2/3 of that total premium are going to go into the employee's medical leave bucket. 1/3 of the total premium is going to go into the family leave bucket. And the employer can make the deductions from the employee's wages 100% of the premiums for the family leave bucket. So the employee is going to be totally funding the family leave bucket on their own. And then 45%, the employee will fund 45% of the premium for their medical leave bucket, and the employer is going to be responsible for funding 55% of that medical leave bucket. Now, if you are an employer of less than 50 employees, you don't have to put that 55% into the employee's medical leave bucket. You won't have to be funding that. You can, and there is going to be some small business assistance that will allow you to do certain things. But so employers, again, of less than 50 employees, you aren't going to have to be funding that portion of the premium. But just know, this is still going to apply to employers of all sizes. So all the employees are still going to have to be paying into this, whether they work for a big employer or a small employer. Doesn't make any difference. And again, the employees are not going to be able to opt out of the system. There's a lot more to the, yeah, go ahead.
Is there a distinction between exempt and non-exempt on this one?
No. Nope.
So exempt employees
Yep.
are also subject to this?
Yes. Yep, they are. Unlike the paid sick leave program, where exempt employees can get out of that, not in this case. So it's going to come right out of your salary. I didn't put up any of the financial impacts. It's fairly small. I mean, when you see the few cents or less than a couple of dollars per paycheck, but that could be really significant for some employees that aren't necessarily planning on having maybe a living paycheck to paycheck. It's probably good to start gearing those folks up now that this is what the impact's going to look like on your paycheck come January 1st, and you can't opt out of it, so you need to start pre-planning now that this is what it's going to look like on January 1st for you. So with that, but great question. Any other questions about that? So that's all that I had in my allotted time there. There's much more that I could go on about with respect to these employees, but I think those are kind of some of the highlights that employers would probably want to know, and particularly maybe new businesses that might be starting up. Great. With that, yeah.
So in the startup world, one of the questions that constantly comes up is three people get together, they're co-founding a business.
Right.
One of them may be doing it full time. The other two are still holding on to their day jobs. It's my recollection that, like, the city of Spokane, for example, if you are an executive officer of the company, you're not necessarily deemed to be an employee of the company. But can you address where that line falls in city, state, and federal law in terms of when is someone deemed to be an employee if they're actually the owner of the business?
Right. That I don't, with that specific definition with respect to owner of the company, I don't know the answer to that, but I'm wondering if those individuals might fall within some kind of exemption. I mean, if you're bringing special skills, you're a professional, you have some level of training and expertise that you're bringing to the table with respect to that, you might fall under one of the exemptions that we talked about earlier. With respect to company ownership, I don't know the answer to that off the top of my head, and I'm not one of those smart business attorneys. Right.
The owner has to be an employee. I know this because I have an escort and I have to be on payroll, whereas if it were a partnership, I wouldn't be on payroll.
Right, and those are questions for like smart business attorneys, and I don't know any business law like that. But that is a good question. And I have actually had a company that I was working with, and one of the things, I think it started off with very much how you described. It was a few individuals that got together that had a certain level of expertise in a particular area that they were starting a business in. So they were all kind of like stockholders and things like that, and maybe arranged in some kind of arrangement that allowed them to be all owners. And then as they were hiring people into the organization, they weren't hiring them necessarily as employees, or certainly weren't treating them as employees. They were all like giving everybody kind of, stock options. So now suddenly everybody was an owner within the organization, and nobody was being treated as an employee, all the way down from the person who was, a staff person at the front desk, all the way up to, the true one of the founding individuals of the organization. And I had a very hard time explaining to these individuals, like, that might work for you as a mental model, but that isn't going to work from, being audited as a standpoint of, are you treating these people appropriately as employees and paying them, accurately, and there really should be non-exempt hourly employees, regardless of whether you're giving them stock options and considering them to be part of the ownership. That can be definitely challenging. And I think I maybe referred them to a business attorney to ask them that you might want to think about restructuring this appropriately. So, excellent. Yeah.
Can I ask about my personal situation? So
Sure.
I have a business model to hire retired engineers
Mm-hmm.
for short-term projects to support our clients who have the need for specialized expertise. So if I parse that, am I getting myself into trouble by saying I hire retired engineers? Is there going to be some age discrimination issue there, or should I stop saying that?
Well, I mean, I think if you are, it probably comes down to how are you treating the engineers. I mean, the engineers would be the one that had the claim that if they were being discriminated against because you were referring to them as retired engineers and somehow treating them differently than, other individuals within the organization, would they come back and claim they were treating me differently? It was an age-based issue because, if you're over 40, you fall into the age-protected category under the Age Discrimination and Employment Act. But they'd also have to demonstrate that they were being, somehow treated differently and maybe, more negatively. They weren't being paid as much as the other engineers, or they weren't being, I think it depends on how who are you telling that they're, when you go out.
Business model to people. I'm trying to build a community of retired engineers. I'm trying to scoop up all these retired engineers and bring them together into a community, and where they come together and work together on projects. And then, of course, the second part of it is the independent contractor. My vision is people are working 40 hours a year, 100 hours a year. I have one guy who works 500 hours a year, and I assume I'm fine for independent contractor status. These are senior engineers, highly compensated, working at most 500 hours a year.
Right. And really what it would come down to is, again, are you controlling the manner, method, and means in which they're doing their work? Or are you just you're connecting them with somebody who needs engineering services and you're sending them out to, to do that kind of thing?
Hiring the world's expert in XYZ where I can barely pronounce XYZ. I'm certainly not directing his work. As you said, connecting him with someone. Yeah.
I mean, that does sound like we are sort of like a professional staffing agency for engineers. And a lot of times staffing agencies, those individuals are considered to be your employees, even though you are leasing them out or, sending them out on jobs, to other organizations. And then it gets into a big joint employer issue as to who's the true employer, of these individuals. So I'd probably need to know a little bit more about I'm happy to talk to you more about, what that setup looks like. I'm not quite as concerned about you calling these folks, selling your business model as, retired engineers. You could be a retired engineer and be 39 years old, I suppose, if you were really successful at it. And, so it doesn't necessarily mean that you're, I wouldn't say a bunch of old engineers or, elderly engineers, maybe just, experienced engineers.
No, the point of the business model, of course, is I'm not providing health insurance. I'm not
Right.
hopefully on Medicare, so that's taken care of.
Right. Yes, and I suppose if they're of a certain age, then they would fall into that category, and you don't have to be. And they're essentially your 1099 type. Yeah.
I am an employee because I'm an expert, so I have that one payroll for one person. I am an employee, not have any
Do these people typically provide services to other Are you their only gig?
Usually, but I don't prevent them. It's fine if you
Yeah.
work for 100 other people.
Do you use some kind of, I mean, it does make me a little bit uncomfortable that you're considering them to be independent contractors because your entire business is based on their services that they're providing, to others. So it does make me a little bit uneasy that you're independent contractors when really your entire business exists for the services that they're providing. I mean, they're not there providing you with engineering services. Their whole purpose is to provide your clients with services. So it does sound a little more like a temporary staffing agency to me. And usually in temporary staffing agencies, all the temporary workers are the employees of the central body who then is sending these people out to be hired out as temporary workers for other organizations. So it does make me a little bit uneasy.
Well, this is a new business model, so there's nothing for them to come back with me. The company, as an aside, has been in business for 18 years with all employees. And so I've been audited by ESD and O&I 100 times, and everybody was always an employee.
Mm-hmm.
And I spent all of my time on mission, and I decided I didn't want to do that anymore.
Sure.
And so I decided this is a decision to change the business model, to stop having everybody as a full-time employee.
So they actually are continuing to do the same type of work they did for you. Oh,
I shut down. This is a clean break. I had full-time employees, young people, families, kids.
mm-hmm. Oh gosh. Okay. Totally different.
I'm shutting down that bit. But I'm just saying, I know about ESD, I know about those rules, but I don't want to do that anymore. It's a very deliberate decision. I don't want to do that anymore. I want to do something different with bringing together retired engineers who will come together and work together to collaborate on projects that require, these are highly skilled people with very specific expertise.
Yeah.
Yeah.
Like I said, that makes me kind of uneasy.
Doesn't make you, it
Yeah.
doesn't make you nervous.
Yeah.
Yeah. What if I require them all to have business licenses? So
That's one factor that they would look at, but it isn't going to be, it's not going to be the determinative factor.
what if just nobody makes less than $100 an hour? People are making
The amount of money isn't going to be, no.
show that they're highly skilled and they can take care of themselves.
And it isn't necessarily the skill level that makes any difference with independent contractors. You have a lot of independent contractors that would be highly skilled, like the IT people that I was talking about earlier, that, we have a business that we hire to come in and do all our IT work. We don't have a dedicated IT professional, so we hire this business that when somebody's computer breaks down, we call them. They have the people that answer the phones, that walk you through the problem. They can log into our computers, they come in and do the work. Those people are not our employees. We use them, but they provide services to all kinds of different businesses in Spokane. They're all very highly skilled and highly compensated. We pay them a lot of money, but they're, not our employees.
These are people that I never lay eyes on. They're not here.
Yeah, I'd probably have to I would feel more comfortable having more of a discussion with you about it, but getting a little bit more down into the weeds about it, because it's, right. Yeah, it isn't clear cut. I mean, I wouldn't say, oh yeah, that's a slam dunk, definitely independent contractors.
I guess I would like to talk to you further. I guess a better way to say it is, if I'm set on doing it as independent contractors, because that's part of my business model, then is there a way to structure it so that you stay within the lines?
Probably. I mean, I think one of the things you'd want to think about doing is using independent contractor agreements with all the people that you have that are providing services. So make it really clear in this. And again, the written agreement isn't going to be definitive, but I mean, at least you two are on the same page as to what their status is, and nobody can come back later and say, I really was their employee. They should have been paying, X, Y, and Z on my behalf, and they weren't. And outlining, in the inhibited from providing services to anybody else. This is not a situation where there's a non-compete or anything like that. I have seen employers who subject their independent contractors to non-compete agreements, which in and of itself that makes no sense to me. You can't have an independent contractor that you're preventing from competing. That So anyway, that's neither here nor there. But so you want something in your independent contractor agreement that says you're free to, engage in services, with anybody else as well. So yeah. So thank you very much.